Welcome to County Portal, your simple source for local government services and public records. Let's get started.
What percentage of criminal cases in the United States are actually dismissed? It's a critical question that cuts to the core of our justice system, and the answer is likely much higher than you imagine. While the exact number varies by jurisdiction, studies of large urban counties show that a surprisingly large portion of felony cases, often around 25%, are dismissed before ever reaching a trial verdict. This doesn't always mean the defendant was proven innocent, rather, it reflects the complex realities of building a criminal case. So why do so many cases get dropped? There are several key reasons. The most common one is a lack of sufficient evidence. Prosecutors have an incredibly high standard to meet. They must prove guilt beyond a reasonable doubt. If a key witness recants their story, if physical evidence is weak, or if crucial evidence gets thrown out by a judge because of an illegal police search, the prosecutor may have no choice but to dismiss the case rather than lose a trial. Another major factor is witness problems. Sometimes the main witness for the prosecution becomes uncooperative, cannot be located, or their credibility is challenged so effectively that they are no longer useful to the case. This is particularly frequent in domestic violence cases, where a victim may decide not to testify against their partner. Then there are procedural errors made by law enforcement or the prosecution. The system has strict rules, and if a defendant's constitutional rights are violated, for example, they weren't read their Miranda rights or the police used a faulty warrant, a defense attorney can successfully argue to have evidence suppressed. If that evidence is the foundation of the case, a dismissal is almost certain. It's also important to understand the role of plea bargaining. A serious felony charge might be dismissed, but it's part of a deal where the defendant agrees to plead guilty to a lesser offense. So while the original charge is gone, the person is still being convicted of a crime. Finally, many jurisdictions use diversion programs for first-time or low-level offenders. In these situations, a defendant can complete requirements like drug counseling or community service, and in exchange, the prosecutor agrees to dismiss the charges, allowing the person to avoid a permanent criminal record. A dismissal is rarely a simple story, it's a reflection of evidence, procedure, and strategy within our legal system. Thanks for watching and exploring this complex topic with us. If you found this video helpful and want to learn more about how the law really works, please hit that subscribe button and turn on notifications so you won't miss our next video. We'd love to hear your thoughts in the comments below.